Oh, thank you very much, Sandrine. Bonjour à tous. Sorry to have to give you a talk in English. My French is still nowhere near the level I would need to be able to talk to you about this subject in French. If I go too fast or you don't understand a word, please feel free to stop me midstream. Just ask for clarification. I'm very happy to slow down and explain things. So I've given my talk today the rather long-winded title, Progressive Politics, International Law and the Global Political Economy, for a specific reason. In this talk, I want to foreground political engagement, and specifically transformative politics of a left-wing variety, and to explore the connections between this general field, which I'm calling progressive politics, between this international law, broadly conceived as well, and then the relationship between these and specific elements of my own research connected to the global political economy. Now, I know that foregrounding politics and speaking about the global economy might be slightly unusual for a talk to students and scholars of international law. So I'm going to spend a bit of time elaborating on what I have in mind by progressive politics, and also what I have in mind by the global political economy, and their connection to international law. Although I hope this will become clearer throughout my talk as a whole. As a broad aim, I intend really this talk to give an introduction to the approach myself and various other critical scholars have taken in applying the insights of Marxist political economy to the field of international law. So the rather nebulous progressive politics that I refer to is a placeholder really for traditional left-wing socially orientated politics. And I prefer this because the old left-right division leaves open, firstly, the continually reclaimed vision of a sort of neutral centre ground, supposedly free of any extreme positions. And I see this vision really as a dangerous fallacy, closely paired with the vision of economics as essentially being apolitical, that there is one kind of middle road way to govern a society, and presumably if you can handle your economy well, then it will always grow and everyone's very happy. You can't be political about that. There aren't political choices to be made. Also, particularly in the UK and quite recently, we've seen the weaponization of the idea of left-wing politics, with the notion that some variants of a kind of hard left have infiltrated the Labour Party, that's the main opposition party in the UK, under Jeremy Corbyn, who's the latest leader of this party in the UK, and that these kind of infiltrators somehow plot to undermine the British state in some kind of very long-winded and roundabout manner. And this dismisses the fact that enormous number of people in the UK who desire a meaningful change, in policy direction particularly, have joined the Labour Party, particularly because this new leadership was promising something significantly different in policy terms. Sorry, I don't know how much you know about UK politics, but the Labour Party under this new leader became the largest left-wing political party in Western Europe, and now has a membership of over 500,000 people. So it's a significant shift in UK politics. And this vision that this is somehow like the product of a hard left sort of infiltration is actually laughable, because all the hard left parties in the UK would have had like a combined membership of around 2,000 people at the most. And it was a dwindling membership at that. I've also seen a similar process, amusingly, deployed by the right in France in response to normal French people adopting progressive political positions, such as supporting the rights of migrants. I recently watched an amusing video on my TFI about Marine Le Pen's visit to Château d'Ouble, if I'm pronouncing that correctly, where she accused those protesting her visit as being militant antifa de l'extrême gauche, as a way of dismissing and ridiculing their opposition to her politics. And the video then interviews a series of protesters, asking them if they're from Marseille, and all of them were local to Château d'Ouble, and none of them identified as extreme left. But what I find interesting about this is it represents for me a concerted effort to rubbish the political actions of those who are pushing for a shift in policy, and a shift away really from the neoliberal economic model that has rapidly expanded the wealth and power of the already wealthy amongst the world's population, and concurrently immiserated many of the poorest and the most vulnerable people across the globe. In my mind, then, quite simply, people who with progressive politics are those who would like to see this process challenged and reversed, and those who have in mind a more meaningfully democratic society with an economy run perhaps with the care for the environment and for the people who live inside it. I choose this open conception of progressive politics because, broadly speaking, people who see the world in this light, as riven by sort of greed and violence, desiring a transition to a different way of being, they have a common vision of international law in this story. They see international law as a force for good in the world, a force that's sadly underpowered and incapable of opposing entrenched corporate and national interests. And these interests that just pursue power and profit above all else. In essence, people on the left see international law as largely separate and opposed to the world of international politics and economics. So in this instance, we have law as a sort of a nice law, orderly society, and on the other side is this horrible world of political conflict and economic sort of mistakes, and that the two are not linked. Now, there are a variety of cases I could use to illustrate this, but two of the most prominent, particularly in the UK, are that of the treatment of Palestine and the Stop the War movement, which began after the invasion of Iraq in 2003. Now, with the former, the building of Israeli settlements in occupied territory and their brutal treatment of the Palestinians present, at least on the surface, clear violations of international law, of the laws of occupation, of general human rights violations, and violations of the laws of war during the 2009 bombardment of Gaza, for example. This case even has the benefit of a clear majority of international opinion. The latter, the invasion of Iraq in 2003 by the US-led coalition, has also presented a more or less agreed-upon violation of the prohibition on the use of force. Now, possible legal ambiguities aside in relation to these cases, and we could talk about that later, what these two cases have resulted in are significant social movements with progressive politics, those in support of the Palestinians and the anti-war movement in this example, that articulate their politics using the language of international law. They then decry the illegality of that which they oppose, be it the building of Israeli settlements in the West Bank or the waging of war without UN Security Council authorization. Now, I would argue that on a political level, this is deeply problematic. Progressive political movements have hitched their wagon to that of international law, and consequently rooted their opposition to imperialist war, ethnic cleansing, stealing of land, to the legal status of these activities. Concurrently, this links progressive political struggles directly to the activities of human rights lawyers, courts, judges, and related enforcement measures. The path to achieve these left-wing political objectives begins to take shape as an effort to strengthen international law and to broaden its reach. Now, if you see international law in the positive light that I postulated above, it isn't necessarily a bad thing, but it does require a very particular view of the law, of lawyers, and of the practice of lawyering that is questionable given any concrete analysis of the current function of international law taken as a whole, and that's what I'll be arguing today. What happens then to these movements, these left-wing movements, and their political opposition if the requisite legal boxes are ticked? For example, the invasion of Iraq in 1991, complete with the use of depleted uranium, was described, admittedly by the protagonists, as one of the most legal wars ever fought. Did that make it just, or something that you should support? There's an open question there. Also, as one of my favourite authors, Arundhati Roy, has noted, this commitment to international law, and particularly to the language of rights, shrinks our imaginative horizons in dangerous and problematic ways. A more equal distribution of wealth, respect for community living, these things can be replaced by the pursuit of fundamental human rights, rights which should represent the baseline the very least of the things that we are demanding. As Roy puts eloquently, what should be the minimum becomes the maximum, all we are supposed to expect. In addition to this, the sanctity of rights discourse creates enormous pressures for conformity, to hold the line with international law, particularly if it is seen to be under threat. In times like the present, in the midst of dominant austerity economics hitting the poorest hardest and rising nationalist sentiment, this baseline of legal promise presented in, for example, the human rights regime, becomes beyond reproach. In such times, those who criticize international law as insufficient, or far worse, as a misdirection, these can be easily painted as terrible people. And if you are one of those people, you don't get invited to too many international law parties. But there is a further critique beyond these cautionary points, and this is where my research comes in. One that focuses on the role of international law in the global political economy. This questions the positive vision of international law through the very nature of the legal relationship, or the legal form, is one way of talking about this, noting the inseparable relations between commodity production, capitalist social relations, and the law. And those of you, I'm not sure if you received the reading material associated with this, but if you've read China Mieville's piece on the commodity form theory of law, you'll already have a good idea of the basic theory that underpins this work. But extended internationally, this critique highlights the fact that the contemporary global political economy, with all of its horrendous aspects, is entirely underpinned by law. It is both enabled by and articulated through legal means. It is this basic nature of law which I and other critical scholars have attempted to illuminate via a concrete analysis of the totality of international relations, of which international law forms an integral part. This broader international system is what I'm referring to as the international political economy, one characterized by capitalist production for profit, the dynamics of core and periphery exploitation, and imperialism. Now, some of the most seminal texts you can read in this vein relating to international law are Anthony Anghie's Sovereignty, Imperialism, and the Making of International Law, China Mieville's Between Equal Rights, and the theoretical critique presented by Marty Koskiniemi's From Apology to Utopia, and also in his latter work, The Gentle Civilizer of Nations. The broad question raised by this kind of scholarship is this: what are we to think of international law, given its role in structuring the world that we live in, the integral relationship between law and capitalism, and the relationship between law and imperialism, and further, the general indeterminacy of law on a theoretical level? Now, what I want to do in this particular presentation is very simple, actually, is to juxtapose the supposed weakness of the prohibitions on the use of force, for example, the degradation of the environment and the abuse of human beings, against the fast and effective measures that exist under international law to claim compensation for loss of expected profits or the expropriation of property. In essence, to preserve streams of wealth extraction from those who are in need of investment, i.e. the poor, and to the already wealthy. In a way, this can be seen as a form of extension and elaboration of China Mieville's provocative critique of international law. Now, his critique was to say that the chaotic and bloody world around us is the rule of law. Equally, the world in which the quality of the environment and human life come second to the profits of corporations and the powerful is also the rule of law. Law used to lock in policy measures and prevent the progressive politics that I've talked about. Law used to insulate policymakers from democratic accountability and to remove the ability of local communities to effect meaningful change. And most crucially, in a world of rapidly growing and already extreme inequality, the law prevents effective redistribution of wealth. Now, with this as a somewhat long-winded introduction, I want to flesh out this grim picture of the function of international law with a brief examination of the example of the financial crisis as it manifested in Greece, and to link this back with some early examples of the role of debt and imperialism under what was known as the Roosevelt corollary, and then to talk a little bit about the contemporary function of this under the current system of investor-state dispute settlement, before finishing with some concluding thoughts. Now, Greece provides a useful and depressing example of how rights can appear in international law. And I would argue that this critique applies to law more broadly. The Greek government, this is just one aspect of the crisis, was taken to the European Committee of Social Rights by Greek pension funds, arguing that their social rights were violated under the austerity regime instigated as the Greek experience of the global financial crisis began to bite. Now, in her analysis of the case, Margot Salomon states that, in its defence, Greece argued that the modifications of the pensioners' social protection funds resulted from the government's other international obligations, namely, those deriving from financial support mechanism agreed upon by the government together with the European Commission, the European Central Bank, and the IMF in 2010. Now, the ECSR in this example rejected this argument and ruled in favour of the Greek pension funds. But in practical terms, the consequences of this were meaningless. The Greek state was in no financial position to follow the committee's ruling, which in any case only had the power to blame a country that was already effectively being looted and lacked the capacity to protect those rights. In addition, in legal terms, the Greek government was highlighting a balance of rights in which one right, the right of the Greek pension funds, which were only able to lay a claim on a financially beleaguered state, came up against another right, the external right of investors. And this second right wins by default, because there are severe consequences for non-compliance, consequences which would further disable the ability of the state to meet the rights of the pension holders. Salomon goes on to note, the memoranda imply that the Troika has decision-making power for defining and implementing economic, financial, and social policies which are innately contrary to the fundamental principle of a social state, putting the Greek government and parliament under the direct political control of their debtors. The author goes on to complain, this is my favourite bit, there has been a half-century of standard setting in the area of socio-economic rights, regionally and internationally, enhanced by the normative development of their content. Why was all of this accumulated knowledge and experience ignored? The people of Greece were treated as if there is no history. Now, I would argue that, on the contrary, Greece was treated exactly as a student of history would expect, particularly a student of the history of capitalism and of imperialism. What such a student would know is that there is a long history of the mobilization of the force of the state in support of securing the outward investment of its wealthy classes, and in securing debt repayments no matter the local cost. This is a process that operates in sync with domestic political alignments that favour those same classes. Now, Weber called this political capitalism. And occasionally, international relations literature will talk about this same process as regulatory capture. It's worth noting that, for me, political capitalism is something of a misnomer. Capitalism, as it actually appears in societies, is always and already political, with an inherent tendency in competition and in the profit motive, when located within already vastly unequal societies, an inherent tendency towards monopoly and towards the extension of political control by wealthy elites. But what we're talking about here is the evolution of a political and economic system as capitalism gains dominance as the mode of production. This would be the history of law and the development of capitalism. A poignant example of this extension of imperialist power takes shape in the Roosevelt corollary to the Monroe Doctrine, which asserted the US right to support debt repayments within Latin America following the Venezuelan crisis of 1902 to 1903. Now, in this crisis, Britain, Germany, and Italy blockaded Venezuelan ports to force debt repayments, with the Permanent Court of Arbitration in The Hague favouring the claims of the blockaders. The US was concerned about both European influence in Latin America, but also about the subordination of American debts to European payments. In essence, the Roosevelt corollary placed the might of the American state behind loans made to states included in its sphere of influence. And this ensured that US wealth would be protected even against its European imperial rivals. Now, the Corporation of Foreign Bondholders, which was, what it says on the tin, an organisation in London, attributed rising bond prices at the time to the Roosevelt corollary, with investors believing that default on obligations would be prevented by American power. Michener and Wiedenmeyer, two leading scholars in the field, found that the average sovereign debt price for countries under the US sphere of influence in this time rose by 74%. In the case of the Dominican Republic, among others, this extended to extensive US control over state finances through private companies with state backing, like the San Domingo Improvement Company, operating from 1893 onwards. Of course, eventually the US would formally occupy the Dominican state. Now, what we see in addition to this extension of American imperial power to defend the collection of debts is the ability to defend default in other areas. So, in juxtaposition to this imperial might, the US state offers the only successful example, at least that I'm currently aware of exercising the doctrine of odious debt in international law. And briefly, the doctrine of odious debt is the idea that loans taken out by a sovereign that operate specifically against the interests of its own people, and particularly if it's loans taken out to abuse its own people, these loans are invalid. Now, in this case, the US successfully repudiated Cuban debt after the Spanish-American War. Now, we could just see this as victors dictating terms and justifying it with legal argument, but this charge would be far from unique. The US also shielded the debt defaults of southern US states across the 19th century, with 15 southern states in the US defaulting on their debts, on state debts, in the period of 1840 to 1870. You can see this manifested with US opposition to international arbitration at the time, as they believed that international arbitration would provide a receptive forum for what were primarily British external bondholders. So there are many examples, just a few. The Only Ponsfort General Arbitration Treaty with Great Britain, written in 1897, the Senate declined to ratify this after unsuccessfully proposing an amendment to not allow any claims from Great Britain. Again, in 1911, the Taft Treaty with Great Britain was withdrawn due to amendments that excluded US states from debt arbitration. Interestingly, after the Bolshevik Revolution, the Soviets decried these double standards, as debt claims against the USSR were pursued ruthlessly, particularly in comparison with the caution exercised in confronting the US for its defaults. The Corporation for Foreign Bondholders noted at the time, they lamented that the US government seems to vary its attitude according to whether a dispute lies between its own nationals and a foreign state, or between foreign nationals and its own states. It is alone in the world to adhere in theory and practice to the amazing thesis that its own subsidiary sovereign states can find sanctuary from just debts behind a national aegis. Now, to move on in time, we can see a similar alliance of power and debt functioning today through the ongoing Greece example, actually, that I've already mentioned, but also a good example provided by the Argentinian default of 2001 to 2002, and then finally around the function of investor-state dispute settlement, which for me demonstrates the real teeth that we see today in international law. Argentina's poignant example follows the default at the end of 2001 on its sovereign debt, which was then the largest sovereign debt default in history, only broken by the Greece example just recently. The crisis was linked to a short-lived boom in portfolio investment from 1990 to 95, following economic reforms and seemingly ending a previous long depression in the Argentine economy. The growth in the 1990s was also linked to general boom in commodity prices, particularly linked to rapid growth in demand in China. During this period, Argentina also signed around 55 bilateral investment treaties to attract foreign investment. Conditions changed, and facing the same structural deficiencies as before the boom, the Argentine economy entered recession in 1999. Under IMF advice, the Argentine government implemented austerity measures, and GDP continued to shrink as a consequence. Interest rates on Argentine borrowing soared. The debt burden became unsustainable, and in December 2001, the IMF blocked a tranche of its loan package, stating failure to reach budgetary deficit targets. The crisis culminates in 2001 with default on over $80 billion US dollars. The Argentinian state offered bondholders two opportunities for debt restructuring, in 2005 and in 2010. However, there were numerous holdout bondholders pushing for higher value returns on the defaulted debt. Now, the investment arbitration regime played two roles in relation to the aftermath of this crisis. In 2003, when the new administration reformed the regulatory framework for the economy, particularly for public services which were privatized during the 1990s, they produced a considerable change in the conditions under which foreign investors and particular public service providers had run their businesses in Argentina. Many of these investors chose as a consequence to resort to investor-state dispute settlement, and Argentina faced a slew of arbitration cases at a time in which the economy was struggling to recover. There were 50 cases logged over the period 2001 to 2012, and these cases are extremely expensive per case, even just to defend. However, perhaps more importantly, the investment arbitration regime provided space for hedge funds to seek enormous profits buying up defaulted Argentinian bonds. These were purchased in the US very cheaply following 2002, and it's mostly small-scale investors who panic at times of crisis and then seek to offload their investment for any kind of return, because their feeling is they're going to get nothing, they might as well accept an incredibly cheap offer. Now, these hedge funds then held out against renegotiation in the hope of a change of circumstances. In 2014, Judge Grisha issued a court ruling in the Southern District State of New York, stating that Argentina could not pay its post-2002 restructured bondholders under the pari passu clause. In practice, this prohibited banks from processing Argentina's payments to its restructured bond markets and forced the Kirchner government to choose between paying everyone, the holdouts, or defaulting again on its current debts. Unwilling to strike an agreement with the hedge funds that Argentina lambasted as vultures and financial terrorists, Argentina defaulted again in 2014. In 2016, these hedge funds struck a deal after the election of a pro-market candidate, Mauricio Macri, who stated on his election, "We don't want to remain listed as a defaulter. We want to resolve all outstanding issues. Even though things have not been done well in the past, there's now a change." You can see many instances of this where, as an investor, if you can hold out long enough and wait for the political winds to blow your way, you will reap immense rewards. And only certain groups of people can hold out and also pump sufficient money into this kind of process. Thomas Piketty talks about the example of the émigrés billion, which was paid back to the French aristocracy in 1815 for losses incurred during the French Revolution. In any case, in this example, the profits were significant. To state just two examples of the hedge funds holding out, Bracebridge Capital was awarded $950 million US dollars. Now, this was the equivalent of 75% of the face value of the debt. This was debt brought by Bracebridge Capital around 10 cents on the dollar. Now, if you bear in mind, exchange bondholders, so those people who renegotiated, would have, in the best case scenario, received 30 cents on the dollar for the value of their lost debt. So there's an enormous profit for Bracebridge. NML Capital was awarded $2.4 billion US dollars for a principal investment of around 617 million. In this case, brought probably around 5 cents on the dollar, and the rate of return has been quoted to be in the region of 400% profit. In this example, the bite of law is intimately related to the functioning of the global political economy. The need of states for external finance and investment, and the role of New York as a center for financial flows, grants enormous weight to domestic legal decisions in the US. Now, with investor-state dispute settlement more broadly, we can see a hugely effective system in terms of the immediate consequences, in which 3 arbitrators are able to execute massive and immediate financial rewards based on their assessment of a case. A case that is not open to public scrutiny unless the parties specifically agree for it to be so, and there are significant concerns over conflict of interest and undue incentives for the arbitrators themselves. as they have a keen interest in being reappointed and are arbitrators in some cases and serve as counsel in others, in which the costs are enormous, therefore the profits to be made are also enormous. The average cost in 2013 for cases at the International Centre for the Settlement of Investment Disputes was around $8 million per case per party. Now, think as well, 50 cases Argentina was facing across the period 2001 to 2012 suddenly becomes very expensive. This creates significant vested interests in these cases continuing. They're also dominated by very large law firms which monopolize the industry, as well as significant capacity problems for less wealthy states. One of the most high-profile examples of this was the then, at the time, largest award issued by the International Centre for Settlement of Investment Disputes in Ecuador versus Occidental Petroleum, in which the tribunal awarded $1.7 billion US, 2.3 billion with interest applied, for indirect expropriation. Now, although this decision on annulment was reduced to $1.4 billion, it's still an enormous power for a technically small arbitral tribunal to wield, particularly in which, in this case, one of the arbitrators held a radically dissenting opinion. It's worth looking at Professor Bridget Stern's dissenting opinion if you're interested. So in which case, essentially, you have two people making this decision. There are significant policy implications that followed this process. The Vattenfall case currently underway over Germany's decision to shut down nuclear power plants, which is currently at ICSID. They were also sued by Vattenfall for changing environmental regulation on emissions from coal-fired power stations, in which was settled amicably, as far as I'm aware, for an undisclosed amount in 2012. In any case, the point with these brief examples is to touch on one area of international law that has achieved remarkable teeth in a very short space of time, and which, until rather recently, operated below the radar of most political movements. Although the proceedings often take years and are extremely expensive, and as I've said, an extremely good gig for the law firms involved, something you should never overlook, the results tend to be decisive, more decisive than almost any other area of international law. We can also see that this continues a long history of public state power and law being orchestrated and deployed for the protection of existing wealth and profit, following the Roosevelt corollary, which I've discussed earlier. Now, I would argue that this is not a coincidence, that some areas of law are forced to rely on moral force and others do not. This, for me, tells us something about the nature of law, particularly law in capitalism, and the way in which it functions. What makes a fascinating contrast is the vision of the Corporation for Foreign Bondholders discussing the potential establishment of international agreements on sovereign foreign liabilities back at the end of the 19th century. Now, at this point in time, the CFB states that such agreements would serve as a preliminary condition to the application of moral force, which is, after all, the sole ultimate sanction in such cases. This would be sovereign default. There can be no question as to the advantage that would result from such an agreement. As we can see from the discussion at hand, the protection of international investments has come a long way. And the moral force which the CFB lamented has come a long way from the point at which all it had to deploy in its favour was the moral force. Perhaps the best hope for international law as a tool to achieve progressive political goals are that those areas of international law, be it environmental protection, prohibition on the use of force, social and economic human rights, manage the same kind of transition. Maybe those with progressive politics can hope that the law in support of their causes achieves the same remarkable strength as investment protection today. But for me, that would ignore the historical and theoretical relationship between law and capitalism. And it would be to imagine that law operates somehow in a separate vacuum in which all areas might become equally powerful, something that the history of international law, colonialism, and empire puts into severe doubt. Now, to bring this back to progressive politics and the intimate relationship between international law and the current global political economy, I want to restate more explicitly the effect of the international investment regime on national politics. The most obvious of these effects has been to further narrow the policy space available to governments. although we have yet to see a geopolitically powerful state diverge much from the austerity economics and neoliberal policies more generally, although there's an open question of whether or not China could fit that bill. Not calling it a progressive state, but calling it a state which perhaps wasn't following a neoliberal economic model in the same way. It's become particularly clear, in the UK especially, that many potentially progressive political changes aimed at increasing democratic control and accountability face the threat of serious investment litigation. Now, in the words of the European Union, ISDS, the Investor State Dispute Settlement System, does not limit the EU or a member state's right to regulate. A country cannot be compelled to repeal a measure. And the final part is the most important. It always has the option of paying compensation instead. But if your aim as a state is to begin to alter vast inequalities of wealth and thereby challenge entrenched powerful interests, you cannot do so if you pay adequate compensation at every turn. This effectively undoes whatever it is you are trying to achieve. Admittedly, this is only one of very many problems that confront a progressive political agenda today, but I think it is a significant one. And to reiterate by way of some concluding thoughts, in this talk I was aiming to highlight a tendency associated with the legal form, something the Soviet jurist Eugene Pashakanis termed the gravity of law. That is, its heart in contract, ownership, and exchange. In a material sense, the law favours existing distributions of power and property. Although, in theory, all rights are equal, in the concrete material world, some rights will triumph over others more easily, sometimes purely by the nature of the facts of material life. If I'm starving, I can attempt to exercise my right to some form of social protection, but the time pressures on me are rather different from the ones that operate on those who are exercising their ownership rights over the means to continue living. Legal victories for the prosecution of war crimes, perhaps if we bracket Nuremberg and the Tokyo War Crimes Tribunals, or legal victories for environmental pollution or human rights violations, come from lengthy and expensive processes that are far removed from the injustice of the event. It is rare to see prosecutions succeed, and if they do, the time passed is often extreme, and the remedy rather meaningless, more of a moral victory rather than anything substantive. The pursuit of recompense for economic loss or damages, on the other hand, either they can last for an enormous amount of time, as long as you have the wealth to spend pursuing the claim, and a good example here would be French investors who suffered losses during the Russian Revolution. They pursued both the USSR and then the Russian state ruthlessly for losses, and eventually Russia settled with France in 1997 to the tune of 400 million euros for losses of French investors during the Bolshevik Revolution. It's a completely different state, in a way. Or you can see these cases settled very quickly, and the entire architecture of ISDS is designed to expedite this process, to make legal recompense immediate and effective for trade disputes. And you can compare this to the WTO, which is often seen as a sort of heavy-handed neoliberal institution, but which, in fact, under its own measures, takes an enormous amount of time and lacks the same kind of teeth, particularly compared to investment procedures. Now, free-flowing international capital has become one of the most ravenous and rapacious forces on the globe, protecting itself with a complex myriad of private courts served by incredibly well-paid individuals and enabled by a variety of tax havens. There's potential, I guess, on some front for complexity in this area, particularly as intra-European Union bilateral investment treaties are likely to be undone due to this kind of exploration of a clash of laws between EU law and investment protections, bilateral investment protections. But firstly, this is not due to any kind of progressive political agenda. It's due that this gives undue favour to some parties within the same single market from the EU's perspective. And investors are also then likely to consider routing their investments through entities outside of the European Union, whilst also pursuing low taxation environments. Previously, they might have used Dutch or Luxembourg holding companies. Now they might have to look to Switzerland or potentially post-Brexit UK. In general, the picture looks grim. And as we have an international architecture setting up immense power associated with financial capital, of which international law is an integral part. The weak image of public international law, prohibitions on the use of force, the abuse of human rights, and the degradation of the environment, these all pale in comparison. As I think for me it captures something profound about the dynamic I'm attempting to draw attention to. And that is the fate of politics in the face of the dual functioning of international law and global capitalism. It is also a quote that, written presumably in the 1940s, as the book was published in 1951, and about the 19th century, provides a disturbingly prescient description of the contemporary world. Bear with me because it's quite a long quote. What imperialists actually wanted was expansion of political power without the foundation of a body politic. Imperialist expansion had been touched off by a curious kind of economic crisis, the overproduction of capital and the emergence of superfluous money, the result of oversaving, which could no longer find productive investment within the national borders. For the first time, investment of power did not pave the way for investment of money, but export of power followed meekly in the train of exported money. Since uncontrollable investments in distant countries threatened to transform large strata of society into gamblers, to change the whole capitalist economy from a system of production into a system of financial speculation, and to replace the profits of production with profits in commissions. The decade immediately before the imperialist era, the 70s of the last century, that's the 19th century, witnessed an unparalleled increase in swindles, financial scandals, and gambling in the stock market. Now, I would argue that there's a trend we can see in operation here, a trend to insulate political power and the locating of economic profits from a body politic, as Arendt puts it, from democratic accountability. We can see this process at work in the European Union at the moment, and we can see it as fundamental to the function of international investment arbitration, both supposedly neutral economic areas that have enormous impact on society and are of obvious and immediate concern to political communities. In these processes, the law serves as the handmaiden of international capital, helping to depoliticize otherwise highly political issues. Now, I've intended this as a somewhat polemical and provocative introduction to a historical materialist critique of international law. I hope it's been informative, and I look forward to our discussion. Thanks.